My name is Jonbenet Ramsey, and I'm 5.5.
And that's backwards.
Yeah, how do you prove you're not guilty?
Hello and welcome to True Crime Rocket Science, the most authentic voice in true crime. This is episode 18 of the Khan's Order series, the analysis of two theories. And in this episode, we're really going to look at the criticisms Judge Khan's has of the opposing theory, and also a reinforcement of some of the best parts of what she thinks is the more valid theory, the intruder theory. She's in particular going to emphasize the stun gun evidence. So we'll be picking up the Khan's Order from around about page 72 and stopping at around about page 80. And that'll leave approximately 10 to 12 pages for the final two episodes in this series. Before we get to today's episode, I'm pretty encouraged to see quite a lot of interest in the previous video, Spot the Difference, which just deals with some of the absurdities from the Khan's Order dealing with the debris, just taking what Lou Smith said verbatim. And you can clearly see from the crime scene photos that what has been said and what you can see there are not the same. I'll be doing a similar video tomorrow, kind of in conjunction with episode 19 in the Khan's Order, dealing with John Fernie's statement and some inconsistencies there. If you haven't subscribed yet to the channel, please do. Like, share, leave a comment, and let's get started. So as I mentioned earlier, this part of the Khan's Order, the part that I think is quite interesting, deals with the stun gun. When I say interesting, I mean it in a little bit of a sarcastic way. Lou Smith actually believed that the stun gun evidence, that should really be quote unquote stun gun evidence, was the best evidence of an intruder. And yet the crazy part is you had all this other evidence. You had a ransom note, you had the toggle rope / garrote, you had the nylon cords around her neck and wrists, you had the blanket around her, you had all of that evidence, and then the thing that he focuses on is the thing that's not there. I mean, they never found a stun gun at the scene, so the thing that he's focusing on is the stun gun. So in line with the title of this episode, there is a little bit of justifiable criticism from the judge of the plaintiff's proposed theory, which is that Jonbenet hit something hard in the second floor bathroom and that rendered her unconscious. I think you got to think a little bit about the nature of the injury, and the idiosyncratic aspect of it is that whatever struck Jonbenet on the head, or whatever Jonbenet's head struck, was a surface that didn't break the skin. So you need something that is going to be a relatively smooth surface and also a relatively elastic kind of material. And when I say elastic, I mean something that is going to deform slightly when it makes contact with her skull, so that it's not going to actually break or create some kind of distortion that is going to break the skin and cause bleeding there. So an example of something that isn't elastic, that would break the skin, is something like a hammer or a brick or probably a golf club, right? And so as far as I'm concerned, the plaintiff's theory here is pretty far-fetched. The problem is that the intruder theory is even more far-fetched. I do agree with the judge that this whole idea that Patsy spent the rest of the night staging an elaborate torture scenario in the basement is far-fetched. There are some people who believe that Patsy created the garrote and Patsy pulled on it and all of that. I think that that is absurd, to be honest. I think the most that was done to Jonbenet was her body was moved and a a piece of duct tape was placed over her mouth, and we know whose fibers were found. Well, we know what kind of fibers were found on the other side. And then there was also the wiping down of Jonbenet's body and the redressing of her body and covering it back up in a blanket. And what is quite incredible with Lou Smith's scenario is he seems to envision a vicious perpetrator, yet you have some of these things that are not vicious, cleaning someone, redressing them, wrapping them in a blanket. None of those things are particularly vicious. Judge Carnes also highlights a rope that was found inside a brown paper sack in the guest bedroom on the second floor. And she also points out that the defendants indicated that neither of these items belonged to them. Regardless of its ownership, this is quoting from the Carnes order, there is no explanation why a bag containing a rope would be in the guest bedroom. Well, there actually could be an explanation. You get rope like that used by scouts, and it actually looks a lot like that. And that bedroom was formerly John Andrews' bedroom, so that is a possible explanation. On the other hand, you could say, unfortunately, no one provided an explanation for that, not the plaintiff, certainly. And so there is a problem there. Then it goes on to say, further, small pieces of the material on this brown sack were found in the vacuuming of Jonbenet's bed and in the body bag that was used to transport her body, thereby suggesting that either the bag had been near Jonbenet or that someone who had touched the bag had also touched Jonbenet. Now, what that, I think, suggests is it's possible that what had happened with this stick and noose, if you want to call it a toggle rope, whatever you want to call it, it's possible that something like that had happened before using that rope that was in the guest bedroom. And if something like that had happened before, she'd been tied up, she'd played some sort of game, and there was an awareness of this by her protectors, and they then failed to protect her because it was repeated again with disastrous results. Well, then wouldn't some responsibility be borne by the people who were supposed to take care of her, protect her, right? So what I'm comparing this to is if you had a scenario where Jonbenet was struck with a golf club, and then you know what happened there. Well, if she's struck again, whose responsibility is it for a situation like that? And I'm just saying, if you have a similar situation involving rope and sticks and whatever, then you have basically a similar set of circumstances. Then Judge Khan says, finally, this is at the bottom of page 72, items were left behind that defendants assert they did not own. And one of the items mentioned is a baseball bat not owned by the Ramseys. Now, I find that quite crazy. If somebody says they don't own something, how do you disprove that? And how otherwise do you prove it? I guess the only way is to ask the friends of the family, did this belong to them? But then, how would children know for sure that other children owned a particular bat? But it's one of those strange things about the Ramsey case that should be clear and somehow aren't. But then you've also got to say, so did the Ramseys not own that baseball bat? Okay. Well, did the intruder bring it? If the intruder didn't bring it, then who did it belong to? And if it didn't belong to the intruder, who did it belong to? And you sort of had a similar scenario with the flashlight, where the flashlight was on the kitchen counter and there was a little bit of uncertainty who that belonged to. Remember, there's also the uncertainty of the ransom note. Who did that belong to? Also uncertainty around the paintbrush. Who did that belong to? Also uncertainty around the nylon cord. Who did that belong to? Also uncertainty around the duct tape. Who did that belong to? And I think you get an idea of where Judge Carnes' heart is when she says at the top of page 73, plaintiff, of course, argues that any evidence suggesting an intruder was staged by defendants. Those words, of course, seem to be undermining, seem to be somewhat sarcastic. anything that is evidence of an intruder, oh, that was staged evidence. I've tried to make the point that I think the best evidence of an intruder is basically that broken window, right? And what I've tried to explain is that the window was probably broken that morning in order to create a red carpet for the intruder to go through. Also, to create a red carpet, in other words, why say you'd broken it yourself months earlier? Well, to create a scenario where somebody else knew that the window was open and somebody else made use of that, and somebody else with inside information needs to be the suspect in this case. And who is the most likely inside person? Well, what about the housekeeper? What about the housekeeper's husband? And we do know when they were asked who they thought was likely involved, John and Patsy, they both referred to people they considered insiders. Patsy, the housekeeper, and John, a work colleague, someone that knew them. That was the whole point. And that was also what the ransom note referred to, the idea that somebody knew John, someone knew the inside of the house. I'm not going to touch on the defendants not owning any high-tech brand shoes. I've gone through that before. It says something about the owner of the high-tech shoe that made the footprints at the murder scene has never been identified. Oh, really? It says, in addition, on the wine cellar door, there is a palm print that does not match either of the defendant's palm prints. I'm not 100% sure if that's accurate. I know that a palm print was identified belonging to Melinda. And as far as I recall, but I say this under correction, there was a palm print matching Patsy. So where the Khan's order says the individual to whom it belongs, the palm print, has never been identified, I'm not sure whether that is accurate. So I think it was Steve Thomas on page 237 of his book. I think he said that there were 3 palm prints found on the wine cellar door. 2 palm prints belonged to Patsy Ramsey and a third one belonged to Melinda Ramsey. So this seems to be an error in the Khan's order. I probably don't need to repeat the fact that Burke Ramsey and Fleetwhite Jr. both said they had owned high-tech brand shoes, so that's another error. There was also a pubic or auxiliary hair found on the white blanket in the wine cellar. I also say this under correction. I'm not 100% sure. There seems to be some dispute around it, but apparently the pubic hair belonged to Patsy Ramsey via mitochondrial DNA testing. That was reported on Fox News, I think, in 2002. Anyway, the Khan's order goes on to say, of course, the existence of these shoe prints and palm print is not dispositive, as they could have been made prior to the time of, I guess, the incident of the murder, but they are clearly consistent with an argument that an intruder was in the basement area. So it seems like she's saying that the palm print proves that there was an intruder, and so does the high-tech shoe. The defendants also offer other undisputed evidence that they contend clearly establishes that another male was near Jonbenet at the time she was murdered. Specifically, defendants note that unidentified male DNA, which does not match that of any Ramseys, found under Jonbenet's fingernails. Now, actually, I don't even really want to go into that narrative because it's a small amount of DNA and it's possibly a composite sample. And, something that's very interesting is all the children on December the 23rd played on the carpet around the Christmas tree, right? That's where all the children were playing. And Jonbenet's body was placed on that carpet with her hands basically floating above the carpet or on the carpet, right? And so that is how easily her fingernails could have been contaminated, and possibly even contaminated by other children. Then it also talks here about a unidentified Caucasian pubic hair not matching any Ramsey. Once again, that seems to be disputed. And then I'm not going to go through the rest of this DNA evidence and the garrote and so on. Anyway, it says, as noted, there is evidence that Jonbenet was alive at the time she was strangled and that she may have struggled with her attacker. I think that is true, that Jonbenet was alive at the time that she was asphyxiated. But I don't agree that she struggled with the attack. I believe that she struggled with the cord that was around her neck. Then it goes on to say, this is page 75, specifically defendants point to evidence from the autopsy report indicating that a stun gun was used on Jonbenet. Now I find this quite strange. Does the autopsy refer to a stun gun? It says, because it is logical to assume that Jonbenet would struggle against an attacker she did not already know, and the use of a stun gun helps to explain why no evidence of a struggle was found in any of the bedrooms in the defendant's home. I think that's an excellent explanation for why there wasn't an intruder, that because Jonbenet didn't struggle, because Jonbenet didn't scream out until the paintbrush was inserted, and that was very late in the evening. It was probably close to 1 o'clock in the morning or 2 o'clock in the morning. So the stun gun is very important to introduce this idea of a kind of a predator. But here's the part that doesn't make sense with a stun gun. If a stun gun is used, it is used to immobilize someone. So if someone is immobilized, they can't move, but they can still vocalize. They can cry out, right? And so what doesn't really make any sense is, why would someone use a stun gun to immobilize Jonbenet, but then she cried out anyway? Right? It doesn't really make any sense. Why would they immobilize her, put on the duct tape, one would assume, but you could clearly hear her screaming anyway. Then the judge goes on to say, defendants state that they have never owned nor operated a stun gun. In addition, no stun gun was ever located at the defendant's home, nor is there any evidence that defendants had ever owned a stun gun. Actually, there is some evidence. I think a manual or a video cassette was found for a stun gun in the home. So I don't believe that there was a stun gun, but curiously there was this video cassette. So she goes on to say, plaintiff does not agree that a stun gun was used. However, arguing that the evidence establishing the same is inconclusive. Yet, although plaintiff disputes that a stun gun was used in the murder, he has failed to produce any evidence to suggest what caused the burn-like marks on Jonbenet. Now, what's quite interesting, I think on Reddit, some people have done an experiment with electrified train tracks and looked at what kind of burn marks, and this is on actual skin, on living people. And so it's quite interesting that that explanation is out there and someone has done that experiment. Again, it's a failure from the prosecution to really follow through and to prosecute their case, to defend their case. Specifically, defendants have presented photographs of Jonbenet taken Christmas morning that clearly reveal the absence of any marks on her neck. And then, yet the autopsy report clearly shows reddish burn-type marks on Jonbenet's red and back. Now, I don't think those marks are reddish. I agree that stun gun marks are reddish, but the marks that you see on Jonbenet are much darker. They're very dark brown. They look almost like burn marks. Then it refers to defendants have presented the testimony of Dr. Michael Dobison, a forensic pathologist, who examined the Boulder coroner's autopsy report and autopsy photos. Now, I think this is quite important to highlight here, and it just shows, as far as I'm concerned, and in my opinion, the hypocrisy of the Khan's order. And what it basically does is you have Dr. Dobison examining autopsy photos, and based on the autopsy photos deciding that the injuries to Jonbenet were created by a stun gun. Now compare that to the handwriting experts looking at copies of the ransom note and then been saying, well, that's inadmissible because you didn't look at the actual ransom note. Look at the hypocrisy in that, not applying the same standard. And so you have the judge saying something about the right side of the face as well as the lower left back are patent injuries most consistent with the application of a stun gun. Defendants' evidence that a stun gun was used then stands unrebutted. And so, you know, what is missing here is, if you are dealing with a real person, then you can measure the marks on a real person, right? That's why you need something like, you can't have someone coming after the fact and examining autopsy photos on a aspect of evidence like this. Anyway, she goes on to say something about plaintiff has failed to produce evidence that creates a material dispute of fact on this point, or that offers an alternative explanation for the origin of these marks other than a stun gun. Accordingly, the court concludes that the undisputed facts indicate that a stun gun was used in the commission of the murder. And then it goes on to say, in addition, the court notes that defendants have provided compelling testimony from homicide detective Andrew Louis Smith, who is widely regarded as an expert investigator in support of the intruder theory. Detective Smith has reviewed the evidence, prepared a comprehensive CD presentation that summarizes this evidence, and it also says Detective Smith believes that Jonbenet was subdued by a stun gun taken from her bedroom by an unknown intruder and then sexually assaulted, tortured and murdered. Now, what is also quite weird here is, I mean, isn't the idea of a stun gun in terms of the Jonbenet Ramsey case that you've got a stranger that is now going to try and, you know, stalk his way into Jonbenet's room quietly, and then he's going to quietly reach her bed, and then he's going to stun gun her. But I mean, if he's reached the point where he's right there, then why would he need to stun gun her? The other thing is, a stun gun makes a loud noise. So if you're going to stun gun someone with the object being to prevent a loud noise, well, isn't it counterproductive? Aren't you at cross purposes to what you're trying to do? Bear in mind that Burke Ramsey was sleeping on the same floor. And then it goes on page 77 to refer to Detective Smith's conclusions, and that he's unable to find any motive for defendants to murder their daughter. And I think that's partially true. Some people have taken issue with me saying that I don't believe Jonbenet was murdered. And, you know, how the legal definition of murder is there needs to be intent. And in the CBS documentary, to their credit, they show a scenario where she's struck, but there's no intent to kill Jonbenet. There's intent to, I guess, stop her or silence her or kind of get back at her, but there's not intent to kill her. And I tend to agree with that. And I think that is also the reason why there's a difficulty finding a motive in this case. I'm not saying there isn't a motive, just that there's a difficulty finding a motive for murder. Then it says, absent from the defendant's family history is any evidence of criminal conduct, sexual abuse, drug or alcohol abuse, or violent behavior. I would dispute some of those points, but I'm not going to verbalize them here. I'm not going to say to what extent I do dispute them. I'll leave that to you to work out. Then it says, in addition, there was no evidence that Jonbenet's bed was wet on the night of the murder. I tend to agree with that. That, I think, is one of the weakest points of Detective Steve Thomas's scenario. I think he basically took what the housekeeper told him and just joined the dots very simply and thought, well, that is what happened. Then the court has reviewed the autopsy photographs of Jonbenet, and they are gruesome. They reveal deep ligature marks around her neck as a result of being strangled by a garrote. That's true. I just wouldn't refer to the garrote as a garrote. I don't think it was designed to be one. It goes on to say, the evidence indicates that Jonbenet was alive when strangled and may have tried to pull the garrote off her neck. I tend to agree with that. Indeed, a neighbor heard the sound of screams. Likewise, part of the wood from the paintbrush, I'm not going to go into that. Sadly, Jonbenet's last moments were painful and terrifying. I do imagine that she was in agony, but that the blow that she received would have rendered her unconscious. So if she couldn't breathe, and if she was struggling against that, the blow that she received would have relieved her of that struggle. On the other hand, if she remained conscious, one wonders whether she would have been able to extricate herself from that. Not as difficult to say. I would imagine no. Then it says, admittedly, it is not unprecedented for parents to kill their children. The Chris Watts case is a good example, sometimes even brutally. Yet plaintiff's theory of the motivation for the crime, that Mrs. Ramsey accidentally hit Jonbenet's head on a hard object, thought she was dead, and then tried to stage a hoax kidnapping, seems at odds with this belief that although Mrs. Ramsey later became aware that Jonbenet was alive, she nonetheless proceeded to garrote, torture, and sexually assault her child. That to me is the most absurd part of the whole thing. I agree that there was probably staging, but not to that extent. Then it goes on to say, if Mrs. Ramsey had accidentally hit her child's head, one would think that upon becoming aware that she was still alive, she would have been just as likely to call an ambulance. And so that I've got to agree with the judge on that particular point. Then you have page 78, and once again what you're doing is we're comparing the two theories, both of them, in my view, very defective in critical areas. But anyway, the Carnes order goes on to say, top of page 78, in contrast, Detective Smith opined that there were several factors that could have motivated an intruder. First, the defendants were prominent in the community and had thrown several large events at their home, thereby providing a large number of people the opportunity to learn the house's floor plan. I think there's some truth in that. I think the fact that the defendants were prominent meant that John Ramsey was quite busy, Patsy Ramsey was quite busy, Jonbenet was quite busy, and so what impact did that have on the family dynamic? Did I leave someone out of that equation? Then it goes on to say, second, Mr. Ramsey received considerable attention due to the financial success of his family. In fact, news articles were published that detailed the company's financial success. I also think that that is relevant. I think it's Mr. Ramsey's success had an impact on Patsy. I think Mr. Ramsey's success meant that he wasn't at home as much as he should have been. So I think it's relevant. It's just not relevant to the intruder theory. He goes on to point out that in the weeks leading up to the murder, Detective Smith notes that defendants had a large party at their home in which they entertained hundreds of people from their church. Also, Mr. Ramsey had spoken at his company's Christmas party, and he goes on and on. Then he says, third, Detective Smith states that Jonbenet was a pedophile's dream come true. I think that reflects more on the detective, a statement like that. Honestly, I think that reflects not very well on the detective. I do think that it is, people say, you know, the fact that Jonbenet took part in pageants, was that a factor? I think it was perhaps the most important factor. Jonbenet was dressed up, she was prettified. It's difficult not to look at Jonbenet and think, what a pretty little girl. I remember the first time that I saw Jonbenet's picture, thinking, what a beautiful little girl for something so horrible to happen to her. And I think that is part of the solution to the problem, is that she was, whether you want to say sexualized or the pageantry made her into, you know, a prettier version of a 6-year-old than would be normal. You know, wearing makeup, wearing outfits, posing for a camera, all that kind of thing. You've got to think, well, what kind of impact could that have had on people around her, including other children around her? Then it goes on to say, Jonbenet received considerable public attention as Little Miss Colorado. Again, you've got to think about that, not just through this scenario of Lou Smith, but also through what would her friends, her peers, think about the attention she was getting. It goes on to say, on December 6, 1996, 3 weeks before the murder, she was in the Lights of December parade, an event thousands of people attended. Well, what's also interesting in that parade was that she was she had her own float, and I think her parents at the time were in New York, and Burke Ramsey was sort of also there. It goes on to say, nevertheless, as any theory behind the motivation for Mrs. Ramsey is just a theory, the court has not factored any of these suppositions into its legal analysis. Page 79, it goes on to say, on December 25th, while playing at the home of a neighborhood friend, Jonbenet told her friend's mother that Santa Claus was going to pay her a special visit after Christmas. That's also quite important. I think you need to know who Jonbenet's friends were and also who Burke's friends were. And I think the housekeeper said that Burke's friends were the Walker's child and the Stein's little boy. Anyway, it goes on to say, based on the above undisputed evidence, defendants contend they are entitled to summary judgment because there is virtually no evidence to support plaintiff's theory that they murdered their child, but abundant evidence to support their belief that an intruder entered. It says, as a legal matter, if plaintiff cannot prove by clear and convincing evidence that defendants committed this crime, he cannot demonstrate that their statement concerning his status as a suspect were made with the requisite malice. And here comes the punchline. Are you ready? Defendants further contend that their legal position is buttressed by the fact that plaintiff, Chris Wolfe, has not yet been cleared as a suspect by the Boulder Police Department. And that was obviously when this came out in 2003. So you have all of this complaining that the Ramseys, that the police rushed to judgment, that the police focused on them. And yet part of this judgment is saying, well, Chris Wolfe hasn't yet been cleared as a suspect. So how on earth can you say that the Boulder police were fixated on the Ramseys when they hadn't cleared Chris Wolfe as a suspect? In the next episode, we'll deal with evidence in support of the plaintiff's theory from the Khan's report. Thank you for listening. I hope you have a blessed Easter if you celebrate Easter, and stay safe, and I'll see you guys next time.